there, my name is Keelin Claffey and I'm a solicitor at Latitude Law. In this video, I'll be discussing what a sponsor can do if they want to bring their spouse or partner to the UK but cannot meet the requirements under Appendix FM of the UK's immigration rules. Within Appendix FM, there are two paragraphs that relate specifically to exceptional circumstances for sponsors in this scenario, and these are known as Gen 3.1 and Gen 3.2 of the UK's immigration rules. Gen 3.1 specifically refers to what happens when a sponsor cannot satisfy the minimum income threshold of £29,000 or otherwise satisfy the adequate maintenance requirement, which means that they are in receipt of specified benefits. If this is the case, then the sponsor might be able to rely on third-party financial support in order to meet that minimum income threshold of £29,000 per annum. This is still a very high threshold to meet, and the sponsor and their spouse or partner would need to evidence that there could be unjustifiably harsh consequences for either or both of them if they are unable to rely on third-party financial support to satisfy the financial requirement of £29,000 per annum. The second paragraph, Gen 3.2, refers to what would happen if other requirements under Appendix FM of the immigration rules are not met, or the financial requirement simply cannot be met even with the aid of third-party financial support. The threshold for the Gen 3.2 test is even higher, and the sponsor and their spouse or partner would need to evidence that there would be unjustifiably harsh consequences for them if the application wasn't granted, with specific reference to the Human Rights Act. Examples of scenarios in which the Home Office will consider circumstances to be unjustifiably harsh are if the sponsor has a child in the UK with serious health or learning difficulties, if the sponsor has a genuine parental relationship with a child already in the UK, there are serious cultural barriers or risk of persecution if the couple were to live outside of the UK, or there are mental or physical health conditions that require specific care in the UK. Examples of situations when the Home Office will not usually consider that there are unjustifiably harsh consequences, or when there is separation from extended family, there are language barriers in the applicant's home country, or the general lifestyle would be substantially diminished if the sponsor was required to leave the UK and move abroad to another country. These applications do tend to be quite complex, so if you have any questions, please do contact Latitude Law via our website or give us a call on 0300 131 6767 so we can discuss this with you.